So welcome everybody to this webinar where we will talk about why each company should have an effective IP strategy. And first thing first, you may wonder if the slides will be made available. Yes, they will be made available, as well as the recording of the webinar. So please do not hesitate to ask your questions using the Q&A tool, and we will have time at the end of the webinar to try to answer all your questions. So here's an overview. 4IP Council is a research council. We do empirical third-party research on IPR and innovation, supported by many leading innovators and inventors in Europe. The research is multi-industry, cross-sector, and we work very actively with academia, policymakers, and regulators. Every research paper is based on robust empirical independent researchers. So every time the goal is to promote the role of IP in a very empirical manner. You can find all the information on the website of IP Council. Everything is freely available. Moving on, we have a dedicated area on the website for the SMEs and the startups. Why, you may ask, is because helping European SMEs and startups to optimize their IP assets is key. Is key because the startups and SMEs are important inventors and innovation drivers in Europe. So because the core business of most SMEs and startups is definitely not intellectual property, the goal is to provide curated information to save time and resources to all the companies. So feel free to go on the website where you will find every information you may wonder. And if you don't, then you can always ask us to provide the specific information. But let's go directly to the core of this webinar, where we talk about what is intellectual property and which types do you need. Then why should you care about IP? Then how do you use IP to grow your business? We will conclude with tips to follow and pitfalls to avoid, as well as the Q&A session. First, the IP types, differences, and why, where to register. So what is intellectual property? IP is a property right established in law to exclude others from using, without authorization, your intellectual creations. IP rights, or IPRs, allow you to commercialize and exploit your innovative and creative ideas. We can split IPRs in 5 categories. The first is patent. So the patents protect innovative technical solutions in all lines of industry. Then the copyrights protect original intellectual creations in the creative arts. Then designs that protect the visual appearance of the product. Trademarks protect distinctive marks indicating a product's business origin. And finally, businesses may also opt for protection of their own confidential information from misappropriation by keeping it a trade secret. More details on each category. We will not read the entire table, okay? The table that is on slide 7 and slide 8, the table is available on the 4IP website in an interactive manner. So for each column, you have examples. If you click on the buttons here, you know, where it is indicated here, examples, illustrations, scenarios. The goal is really to make things interactive and give examples. So why do they protect? Let's go through the first column, the patents. Patents protect an invention, a new and innovative way of doing something or solving a technical problem. Examples of what it is protected: invented products and processes in all lines of business. You will have also examples of SMEs that have successfully used inventions protected by patents. How the rights protected? Patents prevent unauthorized making, using, or selling of the patented invention. So you create something, you patent it, and you exclude the others from using what you have patented. Let's move on the copyrights. They protect a work, an original intellectual creation. So examples include audiovisual works, pictures, graphics, architecture, database, software designs, literature, etc. And computer codes as well. So your rights are protected because it will prevent the work being, without authorization, copied, published, distributed, or made available online. It protects the integrity and the attribution of the work. Moving on the designs. So designs, that's important. Depending on the national law and the type of design, they may also be protected as works of art under copyright. In some countries, designs are protected under patent law as design patents. So designs, they protect a new and original visual appearance of a product. So if you are an IoT product designer, you may want to protect the appearance of your product. Examples include packages, containers, furnishings, graphic symbols, computer icons, typefaces, and graphical user interfaces of your computer codes, for example. So it prevents unauthorized use of an identical or similar visual appearance of the same kind of products or services. Trademarks protect distinctive signs that identify brands of products, services. So the brand of your company, for example, you may need to have a trademark of the brand. It will include words, personal names, designs, letters, numerals, colors, shapes, packaging, sounds, etc. Your rights are protected because it will prevent unauthorized use of distinctive signs for the same or related products or services. Finally, the trade secrets. Trade secrets protect any type of useful information for business that is secret and kept confidential. It is the least expensive, as you will see on the next slide, and any confidential information, business methods, customer list, R&D data, etc., could be protected through trade secrets. And it will prevent others from using the confidential information as long as it remains a secret. On the next slide, we continue this table where you can see how long is the innovation protected. For the patents, up to 20 years, copyrights, lifetime of the author, plus 50 to 70 years after the death, designs, that's up to 25 years, trademarks, indefinitely, and trade secrets, indefinitely, provided it is not revealed. That's very important. The trade secrets must stay secret. So do you have to register? Yes, you must register the patents, and filing an application to a patent office is required. For the copyrights, it is not required. Copyright protection arises automatically with the creation of the product. Designs, no, but it is highly advisable. Unregistered designs are protected only from unauthorized copying, and they have shorter term of protection. Trademarks, yes, and you have 3 routes to registration: national protection, EU-wide protection, and international protection. For trade secrets, there is no need to register because it is a secret. How long does it take? Between the time you apply for a patent and you get your patent granted, it could take between 3 to 5 years or even more. Copyright, no need. For the designs, between 3 to 12 months, depending on the country. For a trademark, between 3 and 24 months, and no need for trade secrets. Now the question for the SMEs and the startups that you may work for, how much does it cost? A patent could be considered medium to high, okay? It will start around 6,000 euros. A copyright is very inexpensive. If registered, then that will cost around 15 euros. But you don't need to register if you don't want to. The designs, low to medium, around 500 euros. Trademarks, let's say around 1,000 euros, and trade secrets, nothing. On the website of our IP Council, you can directly click on the different arrows and directly know how to start filing patents, copyright, designs, trademark, trade secrets. So everything is on the website. But now, why IP asset management matters and the reasons to register your IP. Why should you care about intellectual property? That's where we will go through the project that we called 4 Reasons. Okay, because 4IP Council has partnered with several organizations to create freely accessible, comprehensive interactive guides. So should you be a big company or a smaller company, a very busy company or with plenty of time, what you need is to know if actually you need or not patenting or filing copyrights or using copyrights. So we have partnered with all those organizations that are well known. So 4 Reasons to Patent with the EPO, the European IP Update that you may know, and those organizations. And for 4 Reasons for Copyright that were just published last week with ASTP, the Bournemouth University, the European IPL Desk, GRU, and IPAN. And we will go through each reason that we have identified that helps you to just make your own assessment. You don't need to go to a professional to make your first assessment. That's the goal. So let's start with the patents. Patents are one of a number of tools, including trademarks, copyright, trade secrets, as we have seen, widely used to protect creations of the mind. They are a tremendous asset for any organization because they provide market access, leverage in negotiations, funding, and they increase economic and strategic value. This also means that the absence of patents can be detrimental on those dimensions. We have identified 4 reasons. The first one is the market access, then negotiating, then funding, and finally strategic value. Market access. If you go on the website of 4IP Council, you can have access directly to those guides that are interactive. So each green bullet is providing further details or information or illustration or examples, scenarios for each subcategory. So market access, let's start with leverage your research and development results. Manage freedom to operate and reduce the risk of infringing the rights of others. Protect your inventions from imitators and free riders. Enhance your reputation and hold your own in negotiations. If you have patents protecting your inventions, those inventions are yours. You can make sure that nobody else will be able to use your invention without your authorization. And in negotiation, that can be used, like, for example, you can sit at standards development table to enable price negotiation and further protection benefits, impress investors, and facilitate valuable relationship building. So you are working on IoT devices and you have created a new protocol, communication protocol, adding value or enhancing the existing creations. You may want to join the standards organization and try to share your best technology with the industry. And in exchange, you could receive a fair return on investment. So standardization can be used to leverage your technology, share it with a broader uh, audience, and at the same time, you could get a fair return on investment. The patents are assets which can enable cooperation, joint development, or the creation of new companies and adjust any uneven balance of trade. One example is universities. They can file patents thanks to their researchers, their professors, and use then those patents to create spin-off or to kickstart companies that their students may create, and then the university could leverage their patents to help them create those businesses. You can monetize your patents through commercialization. So you are a startup, you have a lot of ideas, you are creating a lot of innovation, and you start investing in patent creation. Okay? Once your patents are granted, you may not want to actually create a product based on your patent, but you may want to leave it to others the possibility to create products leveraging your own technology, which is patented. So you can license your patents and create revenues that will help you to generate new inventions. So licensing, cross-licensing, sales, joint ventures. Cross-licensing will consist in you want to have access to a specific technology that is patented by somebody else. You may want to approach this company and say, hey, I have also patents. Maybe you could be interested in having a cross-license deal where you will have access to my patents and I will have access to your patents. So it helps to leverage your technology in new markets. Again, each green bullet will allow you to get more information on each text. Moving on, funding. So I guess it is something quite important for SMEs and startups, but not only. Using patents can attract investors, increase company value, improve likelihood of success in initial public offering, and receive venture capital funds. By having a patent, you have the exclusivity. So clearly, investors investing in your company know that nobody else could easily copy your product. You can secure patent-backed loans. You have patents, you have no money, you want to raise money, you can use your patent to get a loan. And if you are successful, then you can reimburse the loan. In case you cannot, then they will keep the patent. Access grants and subsidies and benefit from tax incentives. In some countries, by filing patents, you will have access to tax incentives to recover your cost. Strategic value. That's something very important for all the companies. You can build an in-house innovation mindset. So you are a smaller company, but small doesn't mean less innovative. By creating this mindset within your company, you can also get the recognition from others as a leader in a specific domain through the patents that you are filing. You can improve your competitive edge. You can become a valuable partner to important actors in setting up collaborative R&D and technology development efforts. And finally, you can capture the value of strategic R&D investment. Moving on to copyright. So we have seen what it means, but let's just remind you, copyright exists automatically in original creative works without the need of official registration. You may want to register your copyright, you're not obliged. It grants authors moral and economic rights, including lengthy protection from unauthorized copying and use. All organizations are likely to have some copyright protected works. Awareness of copyright is also essential to legitimately use or exploit the creations of others with the authorization of the right holder. Let's move right away to the first reason, competitive edge. With copyright, you can enjoy long-term protection of your works or creations. Same thing on the website of our IP Council, you can directly click on the green dots and get further information that will allow you to make your own assessment if it applies to your company or not. Decide whether to prohibit the use of your works by others. Same. You have exclusivity. Do you want to allow the others, or maybe you don't want them to use your work? You may, as a first step, don't want to have the others to use your work, and in a few months, you can allow them. That's your choice. That's your creation. Or to authorize it on agreed terms. Okay, you can use my copyright, but in exchange, you may make a deal. So you can exclude imitators and copycats. If you are creating something, investing a lot of money and time in your innovation, you just don't want somebody, 10,000 kilometers away to exactly create the same thing for cheaper just by copying what you have created. You can use copyright to give legal protection for software and original databases. That's important. Copyrights can be used for software. You may be pro open source, but an open source license is a copyright. It is up to you to decide which open source license you may want to use and how it could serve your interest and the interest of the industry or the community you are working with. You can enforce your rights in case of infringement through an effective use of the available administrative and judicial tools. Many examples are given on the website. Reputation. So you are a known, but if you start using IP tools such as copyright, you will be renowned, recognized. It could enhance your reputation for creativity, originality based on the creative and aesthetic value of your company's copyrighted creations. It may not apply to your IoT endeavors, okay, but it could apply on other companies or on other parts of your creations. The long-lasting time frame of copyright protection allows for the possibility to treat works as a legacy. Your company, by using IP, is creating a legacy. If you run out of money and you have patents, you have copyrights, you could leverage those tools to raise money or to create equity. Collaboration. Collaborate with business partners who may hold complementary assets to bring your creations to the market. Earn valuable revenue from copyright licensing to business partners. Again, you create something, you protect it. It is your right to decide who you may want to license it to. Funding. For smaller companies willing to raise money, funding is key. You could enhance company value to investors, again, like with the patents. You can attract venture capital. You can secure credit for business development, and you can gain access to public funds and support schemes for innovative SMEs. The European Commission has several schemes that could be leveraged, but countries, national government can have also such a thing. Here today, we don't have the time to go through trademarks and designs, but be aware that we are not giving up, because the trademarks The 4 reasons for trademarks will be published on the 4IP Council website at the end of April. So you will have the full same type of interactive guideline, on trademarks and designs. So for trademarks at the end of April, for designs at the end of May. And as you can see for trademarks, we have partnered with very, very good organizations. So a lot of information will be provided. Just in a few words, trademarks are one of several IPRs that help protect and enhance your brands. A brand is key. Designs are one of several IPRs. They are exclusive rights that protect the appearance of a product. Again, this is key for most of the businesses. How you can leverage your IP strategically? This is something a question that we get from startups very often. There are many ways. And to explain this, we have created the tree of possibilities. And that's very graphic. It is interactive on the website again. We have broken down strategies into 4 categories. Exclusivity, the yellow, then blue, enhance your reputation, then green, commercialization, and finally, very green, attract funding and investment. So the online interactive guide gives you scenarios and details as usual, but let's focus on one possibility for each category. That's the full tree. For the exclusivity part on the left-hand side, the example is injunctions. What does it mean? You can exclude competitors from using your proprietary innovations by obtaining a court ruling, an injunction, which orders the infringer to cease all acts of infringement and refrain from them in the future. That's very important because if I say you are spending money to get a patent, but you have no way to make sure that people will not infringe your patent, then how can you really invest then in patents? There is no need. Thanks to injunctions, you are sure that you will find a way to exclude competitors if you want to. You are not obliged to. In the enhance my reputation category, I've chosen the signal innovation. Okay, through intellectual property tools such as patents, copyright, design, you can signal your business capabilities, innovation, and creativity. You can link the quality and innovation of your product and services with a strong brand image thanks to trademarks, for example. For the commercialization, if you use the option to strengthen position in negotiations, you can leverage your IP assets to boost your bargaining power in negotiations with potential business partners and customers. If they see that you have not protected anything, why they will make a commercial deal with you if anyone can copy or just create the same thing as you? Finally, in the attract funding, for example, attract venture capital. You can reduce risk in the commercialization of your innovations, increase your return on investment, and enhance the value of your business. Attract investors and venture capital by establishing a strong potential for business growth. If they see exclusivity, value, and innovation, they will invest more in your SME or startup. Studies have proved this, and this is clearly a very strong asset. Moving on, we are right on time. Tips to follow and pitfalls to avoid. We have 2 slides, and we try to make a selection. So obviously, you must be able to identify the types of IP you have created or plan to create. Any protections that are already in place and the process of obtaining further protection or IPRs. When you create something, you need to know what is in place in your company to protect it, unless you just want to give it away. You must avoid unlawful use or infringement of others' IPR. This is key. Building a business requires you to make sure that the others' IPRs are not infringed. Because how can you commercialize something when you may have the risk that other companies go after your company and asking your company to pay? So you also must avoid issues with trademarks. An incorporation of a name or registration of it as a domain does not confer trademark protection. So you have your great idea of IoT company, you want to create your startup, you just go on one domain name registration process. Okay, we just registered a domain name. That's not a trademark yet. Avoid patent issues. When you create a product or service, you must factor in the cost of licensing patents from others. If you don't, obviously, smaller companies usually, in 99.99% of the cases, are not sued by patent holders, but it may happen. So it is up to the company to make sure that when you determine the cost of your product, you include the cost of licensing that may apply. When seeking a patent, innovators should also plan a strategy for monetizing their invention. As I said earlier, if you create a patent, okay, you need to know that it will cost you money. So the question is, what is your strategy for monetizing this invention? Then use a non-disclosure agreement, an NDA, with those you disclose your invention. Just to prevent public dissemination and misappropriation by the recipient. You may have not, protected your invention using one of the ways explained earlier, but still you can protect it by having an NDA set up. You must educate all your colleagues involved about the importance of protecting and maintaining IP and the value it can bring to your business. Having only one person within a company who knows the value of IP and what are the processes to protect invention is not sufficient. All your colleagues, you can be small or a big company, but all your colleagues must know the importance of protecting and maintaining IP. Preparation and filing applications for patents, trademarks, registration, and copyright registrations can be made on your own. That's an option that you have. You don't need to go to a costly professional to do it. But retaining a registered patent agent, a registered trademark agent, or IP lawyer should produce better results, but it will cost you money. So if you go through the guides that we have created, through all the information that is provided, filtered, curated for you, you can make a first assessment and make the right decision if you need one of the tools that is described or all the tools maybe. And then if you still have doubt, go to a professional and ask for more information, for guidance, get advice. Thank you very much for your attention, for your time, and please do not hesitate to subscribe to the 4IP Council newsletter to get information and also access the guides that are published and freely accessible.